Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, I'm going to tell you a story. It's a real story. It's been happening. It's been happening for quite a while here, and it's resulted in thousands and thousands of Americans getting disarmed, never having any semblance of due process. And you're sitting there going, oh, you're going to be talking about red flag laws? No, I'm actually going to talk about something far more nefarious than that, because at least with a red flag law, you get some semblance of a court hearing. Now, I'm going to talk about what we've done to our veterans, what we're trying to do to fix it, and how there's still a lot more work that needs to be done. So today, let's spend a few minutes and let's talk about how thousands of Americans were disarmed, and they're all veterans. Okay, America, what brings this up is several things. One, more reconciliation. We will be talking about House Resolution 3944, but I'll tell you the thing that really brings it up is a gentleman over at the National Association for Gun Rights, Ryan Pfluger, who is constantly battling like holy hell to preserve your Second Amendment rights. This is an issue that he is incredibly passionate about. You ask him about it, you wind him up and let him go. He knows this issue backwards and forwards. He's done a lot of educating. He's spearheading efforts over at NAGR to try to remedy some of this problem. And so, Ryan, this video is for you. We're going to talk about House Resolution 3944, which has now been passed out of both the House and the Senate, which means it will move to the president's desk as part of appropriations. What are we talking about? We're talking about military construction, veteran affairs, and related agencies appropriations. All sorts of bills being added to it. House Resolution 3944 is a solution to part of this problem. Now, what is the problem? Well, the inception of it goes all the way back to when Bill Clinton was president, okay? Because while Clinton was in the White House, they passed 27 CFR section 478.11 subsection A. What that basically says is that any veteran who has been deemed to be mentally incompetent, there shall be a notation made on their NICS record. Translation, they will actually be barred and banned from possessing, owning, or accumulating firearms. Now, the real problem in section 478.11 is the following language. A determination by a court, board, commission, or other lawful authority that a person, as a result of marked subnormal intelligence or mental illness, incompetency, condition, or disease, one, is a danger to himself or others, or two, lacks the mental capacity to contract or manage his own affairs. So, two problems here. The first is that while these findings can be made by a court, they can also be made by a board, a commission, or other lawful authority. And apparently, a person, if they're no longer managing their own financial affairs, lacks the mental capacity to possess or own firearms. Now, the big problem here is this. We are stripping individuals of what is otherwise an inalienable constitutional right, and we are not doing so with not only due process of the law, we're not even doing it in an Article 3 court, okay? We're allowing an Article 2 branch of the government, the Veteran Affairs, to do this sua sponte. And even though the individual is then given notice and an opportunity to appeal, that appeal occurs post-deprivation, translation after they've already taken the rights from you. And from what I understand, the appellate process is really meaningless. It is superfluous. It is akin to going outside and throwing rocks at the moon. Now, if you don't believe that board, commission, or other lawful authority creates a problem, consider these statistics right here, where we see that under the VA, this has resulted in the disarmament of over 264,000 veterans. You may recall when President Obama was in office that they tried to do the same thing with Social Security payments, that if somebody else was managing your estate, managing your finances, accepting your Social Security payments, that you too were then mentally incompetent to such a point that you could not possess a firearm. Where did the statutory authority, where did the legal authority come for the Obama administration to implement this program? That's right, it comes from the same 27 CFR section 478.11. Now, the good news is it appears that the insanity moving forward is going to be stopped with the passage of House Resolution 3944. Because the language of that bill as it relates to this topic now reads, none of the funds made available by this act may be used by the Secretary of Veteran Affairs to report a person who is deemed mentally incapacitated, mentally incompetent, or to be experiencing an extended loss of consciousness as a person who has been adjudicated as a mental defective under subsections D4 or G4 of Section 922 of Title 18 United States Code without the order or finding of a judge, magistrate, or other judicial authority of competent jurisdiction that such person is a danger to himself or herself or others. Okay, so that inclusive language now places that ultimate decision, are we or are we not going to disarm this individual, where, that's right, where it belongs, in an Article 3 branch of government, better known as a court of law, where both sides are entitled to put on their evidence, put on their defense, cross-examine and attack the weight of the other side's evidence so that the court can make an informed decision after providing all parties due process of the law. Now, when you think about it, allowing an Article 2 branch of government to just administratively take away a person's constitutional rights not only shocks the conscious, but clearly violates, well, that's right, the separation of powers. And this is an issue that we have seen the United States Supreme Court at least be willing to weigh in on that and start peeling back the administrative state, or what we call the fourth branch of government. But in addition to that, there is a recent case called Jarkesy versus Securities and Exchange Commission, which basically said that the plaintiff in that case, Jarkesy, was entitled to a jury trial under fraud allegations brought to him by the SEC. And the court essentially said that because there were fundamental rights at stake, this was exclusively up to an Article 3 branch of government to make those decisions. The question presented by this case, whether the Seventh Amendment entitles a defendant to a jury trial when the SEC seeks civil penalties for securities fraud, is straightforward. So understand, we're talking about civil penalties only for security fraud. And yet, despite that, the United States Supreme Court found, following the analysis set forth in previous case law, this action implicates the Seventh Amendment because the SEC's anti-fraud provisions replicate common law fraud. And the public rights exception to Article 3 jurisdiction does not apply because the present action does not fall within any of the distinctive areas involving governmental prerogatives where the court has concluded that a matter may be resolved outside an Article 3 court without a jury. So it would appear that somebody who's only looking at monetary penalties from the SEC for securities fraud is absolutely positively entitled to an Article 3 jury trial, and yet our veterans who have served their country valiantly and now have someone managing their finances, well, they can get their rights stripped from them without any due process of the law. Now, again, House Resolution 3944 will stop this insanity moving forward. Well, here's the thing. Until 27 CFR 478.11 sub A is repealed, that's right, any other administration who has far more nefarious attempts, they can continue to do this. And I want you to understand, America, that the existence of 27 CFR section 478.11 sub A can be used in many other ways to disarm you. Don't believe me? We'll take some of these, for example. Let's say you owe back taxes to the IRS, and now the government's of the opinion that you clearly are incapable of managing your finances. Well, perhaps the 27 CFR 478.11 will allow government to disarm you until your tax debt is paid up. What happens if you're receiving housing assistance or having someone else manage your finances involving housing assistance, Section 8 housing or things like that? I mean, the federal government recently lost their biggest tool of disarmament amongst those properties, so why couldn't they just say that, well, that person's incapable of managing finances, that equates to being incompetent, that equates to civilian disarmament? What if, for example, you just decide that under the Department of Health regulations or anything like that, you just don't want to take a vaccine? Not like that would ever happen in this country. Are you now mentally incompetent to such a point that 27 CFR section 478.11 would allow, yet again, the government to disarm you? And so there are two significant steps left to be done. Number one, there is something that has to be done about all of these veterans who have already been stripped of their Second Amendment rights. Now, the Attorney General's office and this administration could probably do something about it. Whether or not the political will and energy is there, that remains to be seen. Frankly, it may involve some litigations. So that's the first thing. We need to undo some of the evils that we have done to these people. The second thing is that we absolutely positively have to find a way to remove from the Code of Federal Regulations, 27 CFR Section 478.11a. Otherwise, all of these other examples and this very issue could rear its ugly head the minute we have an administration hell-bent on civilian disarmament. Okay, listen, we're going to go ahead and link up all the stuff you need to geek out about this for yourself so you don't have to take our word for it. We're also going to link up Ryan Pfluger over at NAGR's, his X account. I recommend you follow him. A lot of good information coming out on that account. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. Maybe you got an idea for a video we should be doing around here. Cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.